Hi there and welcome to ET Now. I'm Ashwin Mohan and you're watching Amicus Curiae, where we get you news and views from the world of corporate law, tax, regulatory affairs and mergers and acquisitions. This weekend, it's a no-brainer. What's been catching the fancy and of course the interest of all market stakeholders is SEBI's direction to in fact impose a trading ban on 331 suspect shell companies. But there's been a setback for the market regulator, as some of these companies have knocked the doors of the Securities Appellate Tribunal and managed to get a stay on that order. Now, this order is an interim order, and of course, the case is still sub judice. So the intention of this discussion going ahead would be to analyze the key takeaways or messages from that interim SAT order for all the stakeholders, whether it's SEBI, whether it's the companies, or whether it's the market as a whole. And to throw more light on that, we're joined by two securities law experts. We're joined by Sumit Agrawal, partner at Suvan Law Advisors, and Yogesh Chande, partner at law firm Shardul Amarchand Mangaldas. Gentlemen, to both of you, thanks so much for taking out time and joining me on the show.
Thank you. Thank you.
Let's start with you, Sumit. Before we move on to the facts of the case, and this is of course an order that was passed in the appeals of J. Kumar Infra and Prakash Industries. Before we move on to the facts of the case and the nitty-gritties of the order, for the benefit of our viewers, could you help us understand, is there any specific definition of what constitutes shell companies? Because to give a background, this was a list that was filtered by the MCA and it was passed on to SEBI, and then SEBI passed it on to the stock exchanges. So the MCA falls under the ambit of the companies law. So under the companies law, Sumit, is there a specific definition of shell companies?
Well, this is an interesting situation because Companies Act, SEBI Act or securities laws, none of them define what a shell company is. The nearest reference we can find is under section 248 of Companies Act, which talks about some company which is non-operational in its business, or company after having been incorporated for 1 year is not started its business. This is not that situation. Here, SEBI's communication to the stock exchanges pertains to suspected listed companies. Now the question is, are these suspected listed shell companies? What is a shell company? What SEBI considered in its mind to be a shell company? All those details, unfortunately, are not yet in black and white.
Yogesh, would you like to add to that?
Yeah.
He's clearly saying that there's no legal jurisprudence to come out with this list of shell companies. So what's the legal backing for MCA to refer to them as suspect shell companies in the first place?
Yeah, so I guess, having said which what Sumit mentioned, I guess the only guidance one can draw from is the particular press release issued by Ministry of Finance in sometime in February.
And that's been referred to by SEBI in its arguments as well.
Correct, and there are some 10 parameters prescribed therein as to what could be considered as a shell company.
Could you highlight a few of them maybe?
So shell companies are typically, as one understand, is an operational company, but for example they may have high cash on hand or high amount of net worth, and of which the greater component being securities premium, low expenses, less amount of statutory payments and things like that. So basically skeleton employees, and those are the 10 parameters which also find reference in the interim order of SAT.
All right, so having established that legal background, now let's look at what the exact communication was from SEBI to the exchanges. Now, post getting the list from the MCA, SEBI had asked the exchanges to place the trading in all such listed securities under stage 6 of what they call the graded surveillance measures or GSM with immediate effect. So there was no time given. That's one part of the communication. Under stage 6, trading is permitted only once a month. That's another part of the SEBI communication. And exchanges were of course asked to verify the credentials and the financials of these companies via an independent audit and if required, a forensic audit. Now, Sumit, if the audits proved that they were indeed shell companies, then SEBI had given the powers to the stock exchanges to delist these companies. But if you look at the communication from SEBI, SEBI was supposed to take action based on the SEBI Act and the SEBI norms. I'm curious to know, was there any backing under the SEBI Act which supported such sudden market-sensitive action?
Well, to put it in perspective, there are two ways to look at the entire situation. Here you have a regulator which is dealing with a situation to weed out the companies which are non-operational. So it can be compared with a situation where you impose a curfew put a law and order situation, and to maintain law and order, there are few citizens whose civil rights are being violated. Rightly, wrongly, that's a different issue. Equally, from the market perspective, from the listed company's perspective, from the investor's perspective, here you have a situation where a doctor telling a patient that you have some problem, I'm going to operate you. I start my operation. If you feel pain, let me know. I'll give you anesthesia. Which one is correct? Which one is not? As we have seen in Securities Appellate Tribunal's order, which is of course an interim order, it says that nobody is finding fault with what you are trying to achieve, but we are finding fault with the manner in which you are trying to achieve.
Exactly. Yogesh, the intention of the regulator, SEBI, and of course the intention of all the other enforcement agencies is very clear, and that's been made explicit by senior government officials as well. They want to clean up the system. They want to ensure that these shell companies are not proliferating, as has been the case in the past. So the intention is fine, and what I think Sumit is referring to is the proceeding or the procedure followed by SEBI in this case. But coming back to my original question, is there any backing under the SEBI Act which prompted such communication or directives to the exchanges?
So not specifically. However, SEBI Act has a broad language that in the interest of securities market and things like that. So you will find those arguments specifically in the SAT order as well, where as far as SEBI is concerned, this was under 11.1 as opposed to what SAT has now ruled that it is under 11.4 and not 11.1. Having said which, to also give you a perspective, there are two levels of communication here, one between MCA to SEBI and SEBI to stock exchanges. Yes. Your question is in the context of SEBI to stock exchanges. Yes. Having said which, as far as stock exchanges are concerned, stock exchanges have right under their bylaws and regulations to prescribe trading restrictions and operational parameters within which securities can be made available for trading. To also make it clear, the way I look at it is this is in that sense technically not a suspension, so to speak, but a heightened surveillance. Securities are listed and available for trading. Yes, of course, on Monday of every month, as far as State 6 is concerned. Stock exchanges do have power under their bylaws and regulations to issue such restrictions on securities made available for trading.
And maybe these were exceptional circumstances under which SEBI exercised its its discretionary powers. But of course, I mean, it's still too early to pass any judgment on that, because as we are aware, SAT is going to hear the case once again. Correct. In the first week of September. Now, what do you make of SEBI's attempt to rely on an apex court verdict and question the maintainability of these appeals by Jaykumar Infra and Prakash Industries on the grounds that SAT had no jurisdiction to entertain the appeals under Section 15T of the Act? Now, SAT refused to entertain that argument. Could you help us understand on what grounds did SAT reject SEBI's stance in this aspect?
So basically, SEBI's argument, as one can see from the order of Securities Appellate Tribunal, was that this directive or a communication issued to the stock exchanges is in the nature of an administrative action. It doesn't prejudice the right of the parties. It is, so to say, an administrative action which cannot be appealed in Securities Appellate Tribunal. Securities Appellate Tribunal didn't find it considered to be an administrative action. According to them, and rightly so, even in my view, if you are hurting the rights and obligations of a party who is the subject matter of a communication, they are of course going to have a right to appeal in Securities Appellate Tribunal. Because if you have a law and policy where such kind of orders are not appealable before Securities Appellate Tribunal, there will be a havoc.
Crux of the argument of Jaykumar Infra and Prakash Industries before the Securities Appellate Tribunal, they argued that there was no hearing, that there was no show cause notice, and essentially there was no opportunity given to them to make their stance clear. Because in their opinion, SEBI should have verified this list and investigated before passing an order. But this is something, the whole concept of principle of natural justice, Yogesh, this is something that I'm sure the regulator is well aware of. So what do you think went wrong in this case? What were the compulsions which perhaps made SEBI pass on this list to BSE and NSE in the absence of a hearing? I'm just curious because this is something which the regulator would have been conscious of.
Yeah, I agree with you. So I am as innocent as you are as far as this particular aspect is concerned, because if you look at it, just look at the paper trail. The MCA letter is dated 9th of June 2017. SEBI issues letter to stock exchanges on 7th of August. 58 days were available. If one does the basic search on internet, you would realize which company is what. Having said which, as I mentioned, I mean, these companies were otherwise available, if I'm not wrong, in the B group category of stock exchanges, etc. They were not even on trade for trade category, to the best of my knowledge, which is also one of the surveillance action available to stock exchanges. So I guess, I mean, I'm as helpless as you are as to what is it that was the compulsion, or as we go along, we'll perhaps realize.
Maybe that's something that might be brought up at the final hearing stage.
Correct.
On that note, Sumit as well as Yogesh, it's time now to slip into a short break. Stay tuned to ET Now and keep watching Amicus Curiae as we continue to dissect some of the key takeaways of SAT's interim order in the suspect shell companies probe. Welcome back to Amicus Curiae. Now, Sumit, one of the major reasons why SAT decided to go ahead and grant interim relief was that SAT felt that there was a delay on SEBI's part when it came to dealing with the representation made by these companies, and SAT was of the opinion that that representation, to quote them, caused serious prejudice to the appellants. What do you make of this fact in the case, that these companies, after they were of course put under this list, made a representation, but maybe SEBI did not deal with it at the pace at which the SAT found suitable?
Well, I believe the message underlying given in SAT's order is that the balance of convenience lies in favor of staying at the moment. Let SEBI be satisfied. And let's see one thing here. Securities Appellate Tribunal has not put a full stop to SEBI's efforts. It's only a comma. That means these entities who are banned right now in a limited way will have to go back to SEBI and satisfy.
In fact, these two companies have made representations to SEBI, and based on what I read from the order, there's some extra information or evidence collecting that SEBI has sought, and after that SEBI will pass an appropriate order. So that's what I understand. Yeah. Yogesh, SEBI's defense before SAT, and this was argued by the councils, was that what SEBI did was that they had merely implemented what the MCA gave them. They were on record to say that they had not made any independent finding or conclusion on this list. They merely implemented it. And therefore, perhaps SAT should keep that in mind. But this is something that did not go down well with SAT, because SAT then pointed out the entire urgency factor, which you pointed out earlier in the first half of the show, saying that it took nearly 2 months for you to take action on this. Yogesh, what is the message from SAT in this aspect regarding interaction between government agencies? Because there are three crucial government agencies in this entire process. There's MCA, there's SEBI, and the exchanges. What does this say about the interaction between these three government agencies and the manner in which this interaction or communication is interpreted?
So before I answer that question, please allow me to go back to the previous one.
Please, if you have an additional point.
So as far as what inconvenience it has caused, or how the rights have been jeopardized, to give you a perspective, if you see, and I will refer to the facts available in public domain. So for example, as on 30th June 2017, if you see the shareholding pattern filed by these two companies especially, I stand corrected if the position has changed today, but on 30th June 2017, around 60% of promoter shares were pledged as far as Prakash Industries is concerned, and 31% of promoter shares were pledged as far as J. Kumar Infra is concerned.
All right.
So please look at it this way. If I am a promoter, there is not only a strong legal case here to appeal, but there is a strong business case in this particular background, which I mentioned to you just now, to also appeal. I have pledged my shares in where I am the promoter to you as a pledgee, you as a lender. This particular arrangement and this particular interim order could be construed as an event of default as far as the lending borrowing arrangement is concerned, because please understand, if you for whatever reason on a given day want to invoke the pledge, you will be stuck with a security which is not available for trading on that day.
Absolutely.
And you will have to
So there are
wait for
certain
a particular Monday in a
practical
month.
business realities
Correct.
which will kick in.
Correct. Having said which, it therefore also ties in with the factual position which these companies have represented, that these are effectively therefore not shell companies. These are not merely going concerns, but these are going concerns with substance in them.
All right, Yogesh, I'll come back to you on my previous question, but I quickly want to get your viewpoint as well on this. What does this aspect of the order have to say about the interaction between government agencies?
Well, I think the underlying point which SAT has tried to make is that you take inputs from whosoever you want, but do an independent verification at your end.
Right. In fact, another point which SAT has observed was that even the BSE or the NSE have not conducted any independent verification.
Well, on that, I have a divergent view.
All right, what's your view?
And in my view, in fact, it would have been much more awkward if the stock exchanges were to challenge the jurisdiction of SEBI or the process, and had they not followed the directions, because they are completely in control.
You know, I stand corrected over there. I don't think it's a SAT, but one of the appellants who had pointed out that the BSE or NSE should have also sort of applied their mind.
Well, for the stock exchanges, the path is always difficult when the regulator directs them.
You know, Yogesh, SEBI's communication has been stayed, and after that, BSE and NSE have been directed to reverse their orders. And this, of course, means that these companies can now, start trading. And that is, of course, the case as we speak. But what do you make of, the conduct of the exchanges over here? Do you agree with him that it's easier said than done to question the regulator when the regulator asks you to take action?
I agree with Sumit what he mentioned, but I would also like to draw your attention to where we have a regime under the listing regulations where stock exchanges, as far as supervising and monitoring is concerned, are at the same time the frontline regulator as far as the listed companies are concerned. And there is an independent line of action which is available to stock exchanges against listed companies if they come across any wrongdoings by the promoters or directors or the listed companies involved. At the same time, it is also the reality of life that stock exchanges are also regulated by SEBI in turn. So we have a situation where as far as stock exchanges are concerned, yes, I mean they will perhaps just follow the instructions given by SEBI.
Is there a precedent to such action being taken by an overseas securities regulator against a bunch of listed companies? Any examples that come to your mind?
So before, in fact, I answer that question, I think I should add here the regulatory perspective as well. To be fair to SEBI, if you want to have an effective surveillance mechanism, your action has to be a surprise attack. And this is what I believe SEBI tried to do here. Having said this, such kind of an operation also happened in US, where Securities and Exchange Commission, in a period of almost 4 to 5 years, suspended the trading of securities which were shell companies, as many as more than 800. But the difference lies in the process. There, the officials of Securities and Exchange Commission tried to independently verify whether those companies are still operating, whether the letters are going to them and received by them, whether there is any response by them. So the principle of natural justice, to whatever minimum way possible, was being followed.
Yogesh, you heard out Sumit. Would you like to add some more perspective to this?
Yeah, so I will stick to the domestic scenario. The point I'm trying to make is GSM surveillance mechanism was introduced in Feb 2017. Immediately in March 2017, around a list of 800 companies were shifted to GSM at various stages. So let's look at a scenario where there is no shell company suspect being there around, or there is no MCA letter. Having said which, the point I'm trying to make is, if I'm a promoter of a listed company, notwithstanding any particular allegation on me, I may still perhaps may want to consider going and challenging this particular aspect of my stock being made available for trading suddenly from a normal category which is a rolling settlement and shifted to trade for trade or various stages of GSM. And therefore, I guess it needs to be looked into more seriously, and I agree with Sumit. The short point being, nobody is denying that the objective which is sought to be achieved is incorrect, but what is sought to be achieved, that the process should be streamlined and principles of natural justice to the extent possible should be followed.
Sumit, as I said, it's an interim order. We're still awaiting the final order. But do you see any grounds on which the market regulator might challenge this order at the Supreme Court? Or do you think that perhaps the message is loud and clear from SAT and the regulator will adopt a more cautious approach?
Well, Ashwin, I see a bigger problem, and I'll answer this question in two parts. One is that technically SEBI can, of course, go to Supreme Court in an appeal, questioning the jurisdiction and maintainability of an appeal in Securities Appellate Tribunal. Having said so, I believe that there is no prejudice which is caused to SEBI. As I said, this is not a full stop, this is only a comma, like a speed bumper, which says, go slow, follow the process, and then take action whatever you want to. So in that sense, SEBI is free to take whatever action it wants to after hearing the party. Second phase of my answer is, today, you are dealing with 331 companies. Even if ambitiously SEBI passes one order a day, I don't see this operation being completed within a year as well.
It's a time-consuming exercise.
Precisely.
Yogesh, what are your thoughts on the regulator looking to challenge this order? I mean, there's a lot at stake for the regulator as well, because there's a lot of coordination between many agencies, and this is, of course, not just the job of one regulator. This is the job of several investigative agencies who are working in a coordinated effort to clean up the system. What is your take on the regulator's chances of challenging this order? Do you think there's enough ammunition for SEBI to challenge this order?
I would think so, yes, quite possible. They may want to challenge it.
But on what grounds? Because as both of you have been pointing out, the process was not followed. So what is the ground that they could perhaps use to challenge this order at the Supreme Court?
So let's look at it from a technical standpoint. I would like to draw a distinction between 11.1 and 11.4. The opening sentence of 11.4 in fact permits to go ahead and suspend a security pending inquiry and investigation, as opposed to 11.1, which deals with administrative orders.
All right.
So the short point being, what happened during that 2 months period, frankly, we don't know. So I think once that is made available, if at all it can be subject to the restrictions, that may be helpful as to what was it that, whether there was any urgency or no urgency, and why it took 2 months.
In this entire scheme of things, it shouldn't be looked at SEBI's loss or the company's winning,
Exactly.
or SEBI versus Securities Appellate Tribunal. Because as on today, SEBI is still free to take what action it wants to.
Yeah, of course, there are orders that it is going to pass based on the representation.
So I hope SEBI doesn't appeal it to Supreme Court and put the processes in place.
I'm going to slip in one last question, and which is a more broader question. And I'll take this from both of you. Yogesh, I'll start with you. Looking at the entire facts of the case, looking at the background, looking at the arguments of both the sides, if you currently look at the legislative setup, if you look at the legal setup, should there be a more tighter, explicit definition of shell companies? Because right at the beginning of the show, both of you said that there doesn't seem to be too much legal backing. So do you think that is required?
I agree with you. There should be, if this is the path which we are going to adopt, as far as our securities market are concerned, it is better we have something in black and white as to what could be considered as a shell company.
We have recently had an amendment to the Companies Act, the new Companies Act Amendment Bill
But
2017.
that still doesn't deal with the shell companies, so to speak.
So which regulator or which ministry should take, in your opinion, should...
I believe in few things. SEBI is always ahead of the market as well. And SEBI recently formed a committee for reviewing fair market conduct regulations, which is looking at reviewing even its fraudulent and unfair trade practices regulation. And I believe SEBI is going to strengthen it there.
All right. So on that optimistic note, let me thank both Sumit as well as Yogesh for taking out time and joining me on the show. So as you heard from our panelists, it's a road bump. It's a speed breaker as far as SEBI's entire effort to crack down on suspect shell companies is concerned. And since it's an interim order, we'll have to wait and watch to see what fresh material, evidence and arguments are in fact brought to public light when the Securities Appellate Tribunal takes up the hearing in the first week of September. But for the time being, though, the message is clear from the tribunal to SEBI that follow principles of natural justice and follow due process. So let's wait and watch to see how the action unfolds during the next hearing at the Securities Appellate Tribunal. On that note, we've completely run out of time on this edition of Amicus Curiae. This is Ashwin Mohan signing off. See you next week.